Greetings to everyone present here. Today we have Ms. Kirti Balasubramaniam, a counsel from Trilegal, with us on a very informative and practical topic of specification and claims writing in trademark. She is a counsel at Trilegal in IP specialization. She had been a senior associate at AZB and Partners. She has been contributing in IT litigation since 2015 and she covered wide range of infamous IT disputes ranging from designs, trademark, copyright and patent. We would now request ma'am to please take up this session.
Thank you for that introduction and thank you for having me here. I was hoping for a more introduction that accordingly, but let's get started. This is one of the least discussed topics out there, even though in fact, it's very crucial to file for a trademark application, and actually it impacts a lot of the scope of rights that a trademark owner gets. But it's not talked about as much. We have some guidance available in the trademarks that the trademark registry has issued. We have, of course, the rules around specifications, in the Trademarks Act, as well as the 2017 trademark rules. So to get started, really, why is a specification even relevant to the protection of a trademark? I don't know if the class can answer me. Can someone raise their hand to respond? Why is a trademark specification in your mind even relevant for a discussion? Can someone unmute the class so we can hear from one or two students? So can someone tell me why is the trademark specification relevant? What's the importance? And what do you know of a trademark specification? Anyone? Okay, so everyone's quite tired, but we can. So the foundation, of course, of what is, right? We know that a trademark can be any kind of brand name, a logo, a figure, any kind of word, letters, even shape of goods and colors can act as marks. So the definition of mark is provided in our law in the Trademarks Act. But what really distinguishes a mark from a trademark? A trademark under law is specifically a mark which can distinguish or which is capable
Sorry
of
to interrupt you, ma'am.
distinguishing the goods of one.
Can you please be a bit louder as we are unable to hear you clearly?
Okay, my mic is working, but I'm not sure why you're not able to hear me. Uh, okay, give me one moment. Let me just check the settings of my mic. Can you hear me now? Can I be heard now?
Ma'am, we can hear you right now, but can you please be a bit louder?
Okay, I'm actually being quite loud. I'm in my room and I'm speaking quite loudly. So would it be possible maybe to turn up the volume at your end?
All right, ma'am.
We can proceed further, ma'am. You are very much audible.
Okay, thank you. So I was just getting at the fact that, a mark can be anything, that can denote a brand, right? Like a logo or a device name or a signature, even how products are shaped can act as trademarks. Even a combination of colors can act as trademarks, like, say for Cadbury, how the shape of goods are, for example, like you have luxury products like very iconic bags like the Hermes Birkin. So all of these are different kinds of marks. But what really makes them a trademark? What makes them a trademark is the fact that they are able to denote and distinguish the product of one company from another. That's the definition of trademark that's provided under the act, which is if you can represent this mark graphically, visually, and it is able to distinguish between the products of one party, then it acts as a trademark. So that's where it becomes important to have proper specifications, because if a mark can be represented graphically but it's so generic that it can't distinguish the product, then it cannot act as a trademark. And therefore, once you have a specific set of goods and services that you describe in a trademark application for your statutory protection, that's when the specification. So really, the value of a trademark is tied to its specification, and that's why it's very crucial to get specifications right when you're drafting them. So typically, this is writing a specification is the job of a trademark lawyer. This is done at the very initial stage when a client comes to you and say, I have a particular brand I'm looking to adopt for a certain service or a certain product that I want to put out into the market. It could actually be both, it could be a service and a product. And so, what's the first thing as a trademark lawyer that you need to understand and do in order to write that specification? For optimum protection, right? You will have to understand the business of that client. You can, for starters, look at, say, an articles of association, look at the website of the client, look at the kind of products that are available for the client on, on social media or on e-commerce platforms if they're selling products. So these are some of the places where you can figure out what a particular business does. Once you have an idea what the business does, you know what the trademark is, then the first thing you do is go check whether there are other parties with similar marks in respect of similar products and services. So say I get a client and they're in the space of clothing. Now I ask them specifically, what type of clothing? Is it, your day-to-day apparel or accessories that you wear? Or is it some kind of specialized clothing? For instance, is it firefighting clothing? Is it clothing for children? Is it clothing for adults? Is it, say, costumes specifically, Indian wear? Things like that. So you'll have to really deep dive and understand what a business does. Now, it's not enough to know what a business does today. In order to ensure that that trademark is valuable for that business in the long term, you will also try to understand what the business wants to do. Do they have any future expansion plans? What do they want to do? Right? I'm currently in the space of apparel and clothing, but I want to expand, in the near future into accessories like bags and belts, or hats. So you'll have to understand the business model of the client, what they're doing today and what they're doing later. Now, I'm also not just manufacturing these products, but I'm also, say, do retailing these products online on e-commerce platforms or in physical brick and mortar retail stores. Then you're not only a manufacturer, you're also a retailer. And retailing is a kind of service. So it's beyond the product, and now it's a service that you're offering to a customer. So you will have to examine from the business of the client what is the product, what is the nature of the products that they're manufacturing, retailers, they're of selling someone else's product, then what is the services that they're offering? Is it online, is it physical retail, is it consultancy relating to retail, or are you a marketing agency helping businesses and do retail and promote their retail stores and retail businesses? So that's really the lay of the land. As a trademark lawyer, your first and foremost important skill is to understand the business of the client. The second important skill to know is how to do your proper trademark searches on the website of the trademark database. There are also other paid subscriptions and services that are available. And once you sort of do your internships or start working, then you'll also get access to those because these are typically paid services that are used commercially, for large scale management of portfolios and things like that. So coming to that second skill of trademark searches, the trademark database is very, very well. And so there's one or two ways you can do searches. And let me show you, for instance, an example of how to conduct a search. Okay, so give me a moment. I'll pull up the screen. To that. So when you can see the search page, let me know. Okay, so here's where you would search. And this is the IP India website. And I think just as a matter of getting a sense of what's out there and how you can look for different trademarks, you should try this on your own. In and typing into Google, saying trademark public search, and it'll get you to this page. So if there are two, like I said, different categories of marks are your word-based marks and then device or logo-based marks. So the device searches are a little bit more extensive, which we won't go into today. Based marks, right? If you have to search for the mark Skechers, this is where the class becomes important. For Skechers, because it's shoes and apparel, it'll typically fall under 25, and I'll come to the classification in a little bit. And you will easily figure this out over a period of time. You familiarize yourself with the classes of goods and services. But just for the purposes of this search, I will just show you. And of course, when you do the search, you have the option of searching for different variants. For instance, you can start with the word Skechers, or it only matches Skechers. So here you go. So under 25, you will see how many Skechers marks there are, and each of them will be owned by a specific entity. For instance, you see over here Skechers USA INC, and but you also see this Mr. Jain, who has applied for the Skechers mark, but he has eventually abandoned that trademark. So this way you'll be able to figure out who has also applied for the identical or similar trademark in that class. And so that becomes your second necessary skill, is before you figure out the business of the client and then do this particular search. So I'm going to stop sharing now. Is everybody with me so far? Okay. Now the third step comes is when you are trying to apply for a brand for your own client. applied for similar for specific services, then you start writing your description. Okay, and here's where we come to the classifications. Now, India has very recently acceded to the Nice Agreement. The Nice Agreement is the agreement under which these goods and services, this is a total of 45 classes of 45 different categories of goods and services. 34 out of these are for goods. So if you're a manufacturer of a product, then you would fall into one of these 34 categories. From 35 to 45, you have classes relating to in the space of software services, software development services, internet, platforms, social media platforms. These will be in different types of service categories. If you have downloadable software, then you'll be in the product category. So similarly, is what we use here in India. It's administered by the WIPO. And how we've come to this is it's obviously ratified, brought into law under Section 20 of the Trademarks Act. And so what we are now acceding to is the latest version, the 12th edition of the NIS classification. And you should really go and look at these categories because they have very, very helpful guidance and elaborate examples as well as explanation of how to write about products in that particular category. Okay, so now you've understood what the NIS classification is. But what are goods and what are services, right? Goods, it's straightforward. We all understand it's a product, it's a subject of trade or manufacture, something which is manufactured. So goods are fairly easy to understand. Similarly, services are any service that you provide to a user. This can include, of course, provision of services as well as any aspects of that service. So for instance, if you're a stockbroker, right, you're providing the service of stockbroking, but you may also be providing ancillary services to that, like financial consultancy, some kind of advisory, how to deal with the stock exchanges, how to open a demat account. These services and products. So if you're dealing with products, you're also dealing with, say, parts of the products. Or if you're dealing with products, then you're also dealing in accessories or fittings related to those products. So goods and services are broadly aligned on those lines. Now, I want to show you the list that from the NIS, but we're having some trouble with the Trademark Office website, so we're not able to get to that. But let's go to the WIPO page. And again, this is a very good resource for you to access. I'm only sharing all of this because I think it's a good place to understand what all resources are available thinking about description of services. So you go to the NIS classification page on the WIPO website. And again, this is a simple Google search, you'll figure it out. Then here's your class index, your goods and your services. So for instance, we were looking at apparel, so which falls under 25. So let's go to 25 and see what it says. Okay, here you go. So 25 is, this is not pet, this is not special clothing, firefighting equipment. Look at particular. It includes all parts of clothing, footwear, headwear, even paper clothing is included. What it doesn't include is also specifically listed. So this is a very good place to start if you broadly know what your client's business is. Okay, so I'm going to stop sharing. Okay. Now that you understand what the niche classification is, what a good is, what a service is, and how you can look up these classification, the next thing is really why is it, what do you need to keep in mind before you start drafting? Why is it important that you draft a specification well? Terms of rights of a trademark owner. So it's extremely important because your client's ability to not infringe a party that has come before it with a similar mark for services, and your client's ability to enforce their trademark against a third party in the future all depends on the rights that they get in that trademark. And the scope of rights is squarely limited by the description of goods and services. So it's extremely important that that is done very precisely. What are some of the say do's and don'ts here, right? If you go too broad, right, then you become vulnerable to validity challenges. So a simple rule I'll introduce here for you to understand why it's important is register within a period of 5 years after you get that registration. Then it becomes vulnerable to a challenge by a third party on the ground that you've not been using it for the services or for the goods that has been registered for. And so it's very important for you to register only in respect of those goods and services that you are going to use. And so an overbroad class or overly broad description means that you won't be able to justify retaining the monopoly or retaining exclusive rights over that entire set of goods. Similarly, if you have a set of services descriptions that is too narrow, then you will not be able to enforce it against the third party. So say you only have it for tea and you've not applied for coffee, or you've not applied for a beverage associated with tea, say, not black tea, or say you've applied for black tea only. It doesn't protect other forms of tea. Then you'll have to go to arguments like this is allied and cognate and things like that. And here's where it's important to keep track of the jurisprudence, of what the Supreme Court and other courts are saying about how broad and how narrow your claims can be. Supreme Court has now held, and it's developed from two specific cases, and these are two cases that you should try and go back and review. One is the Vishnudas Kishan Das versus Wazir Sultan Tobacco case, and the second one is the Nandini Dairy case. So in both these cases, ultimately the courts held that in the same class of goods and services, two parties can have similar trademarks so long as they're different. So in the Nandini case, for instance, there were food items versus milk. In the Vishnu Das case, it was the question of manufactured tobacco being the broad category of products, but actually the appellant was only manufacturing cigarettes, which is a small, narrow category. In case of services or goods where it is applicable for more than one class in niche, how to determine the specific class? Yes, so that's, we're going to come to that next, on how to determine the classes and how to write your description. But first, to understand why it is so crucial for you to have this specification right is for these reasons: for enforceability and to ensure that your client is not infringing the rights of any third party. The other problem is, of course, that if you get it wrong or if you misstate a use, then you will have to get that rectified, and there are time and resources spent on that. So you want to avoid that for your client. Now, coming specifically to how do you determine, right? like I said, the first thing you have to do is understand the business of your client. Once you do that and you go to the niche classifications for the specific category, you choose the category that's relevant for your client's business. If your client's business falls into more than one category, you have to apply for either multiple trademark applications, or you can apply for a single application which designates different classes. So, for instance, and the easiest way to do this, in fact, the most helpful resource available is the EU IPO's classification assistance tool. And let me just show you that very quickly. Okay, so here you are, and you're new to this. You have some idea what each of the classes have. So, for instance, now because of the number of years that we've been practicing, if you say software, I know it's a class 9 product, and I will be able to say, okay, for your specific kind of software, let's do a quick search, and it's most likely going to be in class 9. Similarly, for apparel, I know it falls under 25, so it's easy for me to advise clients now over time. Obviously, that will happen to you as well once you do this long enough. But say you're doing it for the first time and you're looking for a product, you know what your client makes, a product, say bicycles, and you go to the EU IPO tool and you search for the term bicycles, and then you select India. Because while the niche classification has sort of made it uniform across countries that have acceded to that agreement, of how products need to be described in a specification, there are still some differences between each territory, where, say, the EU IPO or the UK IPO is much, much more precise, and they have very definitive rules around the kind of terminology you use, the kind of punctuation that you use in these specifications versus other offices. So India is not so strict yet, but they're definitely going in that direction. So once we search for bicycles, you don't know what class it falls under. You select India and you hit search, and it tells you where bicycles fall under. So if you notice, there are two sets of classes that are provided here. One is class 12, where you have a category of bicycles and vehicles which is provided. There is also class 28, where if you see all of the bicycles that are stationary bicycles and toy bicycles, exercise bikes, these are all falling under 28 as, I think, equipments for, say, health equipment and things like that, whereas regular bicycles for as modes of transportation are falling under class 12. So that's really how you, where you are. And you'll notice that sometimes your client is making products that fall into multiple categories. And so when you describe these multiple categories, you file a single applications with multiple class options, which is a facility available to you when you apply for the trademarks. Okay, someone's asking, there's a question from the class: when we apply for the trademark in multiple classes, and if one or more of those classes are rejected, whether we have to apply for a fresh application or we can be granted registration in other classes in the same application. So here's where typically why we advise that you should not file a multi-class application, because if one class gets stuck, the entire application gets stuck. But that's not the case. If one class is, for instance, rejected, that doesn't mean that the remaining application cannot go on. But it certainly is the case that you will find that if it's a multi-class application, it will get stuck if there's an objection in relation to one class. But that's digressing from the topic of today's discussion. But that's a very good point, because that is another reason why you need to ensure that your specifications are precise, and so that it doesn't get stuck, say, on account of a third party mark. Okay, so on figuring out what the product is and what the specific class is, I think we've understood more or less. Any questions on niece that you have today on the niece classification? I think it's a very straightforward, simple classification tool that's available. So as long as you can describe in clear, precise terms how the business of your client is conducted in terms of the services and goods that the client provides, um, to ensure that it doesn't read on any previous claims or previous specifications of a third party with a similar trademark, and it's broad enough to protect your client in the long run. Okay, so those are the two sort of things to keep in mind when you're drafting. Uh, Now, in terms of the next do's and don'ts, right? What is the kinds of things that you should keep in mind when you're drafting it? One is keep the descriptions as precise. So, apparel is too broad. Specify the kind of apparel. If, of course, your client is a big apparel manufacturer like a Gap or Zara, then you want to have a broad category like apparel mentioned. You need to have apparel, accessories, headgear, footwear, everything included. But when you know that your client is only manufacturing, say, children's clothing, then you can limit it to that, provided your client doesn't intend to explore adult clothing or clothing for adults in the long run, if that's not the intention of the business. Okay. Okay. The next thing to keep in mind when you're drafting is don't pick, therefore, very broad class headings. So, class headings are entirely prohibited because when the registrar examines your application, uh, they are very clear that you are not, one business is not doing all of the activities or manufacturing all of the products that are under a specific category. So out of that broad category, you need to select what works for your client and what doesn't. So broad class headings, which was the norm earlier in order to protect for a very wide variety of products, that's not encouraged today. In fact, the registrar will raise an objection that the category is too broad or the description is too broad. This is because ultimately the goal of trademark law is what? To ensure that parties can differentiate between their products. And so if you're applying for a monopoly over 200 products, out of which 100 you're not making, then you're effectively blocking others from doing that. And so that's discouraged. Okay. The next thing is small, but very, very important. It's punctuation. So when you're talking about different categories, you can say apparel, semicolon, headgear, semicolon, accessories. But when you're talking about apparel, shirt, including shirts, comma, pants, comma. So the comma is to really separate from a broad class the specific items in that broad class, whereas a semicolon is to separate the broad categories, right? So when you're describing, you have to be extremely sure whether you are listing something from a broad category or you are specifying different categories. Now, if you end up putting something in brackets, it restricts the description to what's in the bracket. So, for instance, you've filed for clothing, but in bracket you say pet clothing, then effectively the interpretation would be that your trademark is restricted to pet clothing, right? So you have to be extremely careful of that. And similarly, for instance, I'll give you an example. Like we've been discussing clothing. So clothing falls under 25. Uh, but fire protective clothing is a product under class 9 versus surgical, clothing for wearing in an operation theater, that will fall under class 10. Pet clothing is in class 18. Clothing for, say, dolls or toys, that will fall under 28 because it comes under recreation and equipment and things like that. So uh, you have to be, again, very precise in your understanding, and I'll keep saying this again and again, but that's really the crux of it. Your understanding of your client's business is the most important. Okay. Then we've discussed the Nandini and Vishnudas case. Please do go and look these cases up and read them thoroughly, because there are different nuances that are coming out of this case. But bottom line for both, um, is really that even in one broad class, parties can have similar trademarks as long as they're using it for different goods and services in a way that use for one um, doesn't appear or doesn't confuse a customer for thinking that those two are associated together. Okay, now someone's still asking me about multi-class applications. We can take that offline and discuss it, because it doesn't have anything to do with claims or specifications, but advise not to have multi-class application, as if one class gets stuck, the whole application. But then what to do if my product falls under more than two categories? You apply for separate trademark applications. So yes, it will every additional class in any case incurs additional fee, and so you'll have to just weigh that against the pros and cons of how important each of those specific classes are. Okay. Now, how do you choose these classes? Was somebody asked me. Obviously, if it's different products, you choose different classes. But really, if you want to have the broadest possible protection, you also choose ancillary classes. So, for instance, if you have a class for automobiles, you also want to choose a category for parts and fittings if they're falling under a different class of goods, because it's ancillary to what your client's main core business is. But you don't choose ancillary classes. For instance, if I'm an apparel manufacturer and I am retailing that apparel through my own stores, while I will choose 25 and 35 for retail, I will not choose 35 for advertising, or I will not choose 16 for advertising materials, because I'm not in the business of advertising, or I'm not in the business of advertising materials. I'm not an advertising agency. It's just part of the activities that I perform as part of my broad retail, manufacturing, and sale business, right? So you have to also understand that difference. While you may be doing certain activities, they may not be core to your business, and they're just ancillary activities for which you don't necessarily need to have protection. Although in the past, companies have been advised to file in these types of ancillary classes, it's becoming harder and harder to enforce that against third parties if you're not actually engaged in that business. Okay, so that's on the broad set of. Now, what are the downsides? We've already discussed this in some detail. Um, your downsides are that you'll have some sorts of validity challenges if and use related claims if you're not using for certain categories. For example, let me give you an example here. Is if you are, say, a financial service, right? You're doing purely wealth management and financial consultancy. But there is another company which has a similar trademark and it's doing stockbroking, right? While these are both financial advisory and consultancy services, if you've not used your trademark for financial services, but say you only have one app which gives some financial information, right? That app itself is a class 9 product. It's not a class 36, which is where financial services fall under. So the subsequent party can always say, listen, you only have an app where some financial information is provided, but you don't actually provide any services in the country, or you don't actually provide financial advice. So can they be distinct? Will they be distinct? So there's always those that confusion and arguments to be made when you don't have use of certain types of goods and services. So apart from drafting and applying for it, you also need to be alive to what your client is finally using it for and what they're not using it for in the long run. Um, okay, then the next thing is, of course, where does it not matter at all how your class description is specified? There's no circumstances in which it doesn't matter, but the limited exception, right, is in case of well-known trademarks, which which are protected across all class of goods and services. But that only happens once a trademark becomes so distinctive and so reputed in its own goods and services that if it's used for anything else, consumers can get confused, or they can, they can be misled into believing that one is associated with the other, or this company has also started this service. For instance, recently there was a lot of hue and cry about why Vistara was, um, you know pronounced as a well-known trademark by a court. And really, the point is this: Vistara is such a popular brand that if it's used for biscuits, if it's used for food, you might think that it's actually related to the airline. If it's used in respect of, say, hospitality services for a hotel, you might actually think it's the airline company that's starting that other business. And therefore, a mark like Vistara, say for instance, got its well-known status. Um, is there any other question that anyone has from whatever we've discussed? Anything else you want to know on drafting and specifically? You want to go
Ma'am,
over
I think there are
something
questions in the
simple?
chat box, so we can address that as well.
Sure, sure. Can you please give an example of this broad category thing? Yes, absolutely. So the first example, for instance, we just spoke about it, is clothing, right? If you just apply for clothing and footwear and headgear, that's the class heading. But actually, you're not producing all kinds of clothing. Similarly, if you apply for automobiles, but you're actually only in the business of cars, or you're only in the business of manufacturing trucks, or you're only in the business of providing accessories for trucks, and not really building the whole truck, or just tires, for instance. That's really an example of broad category versus. And if you look at the Vishnudas case, also the there they'd applied for the trademark for manufactured tobacco, which is a very broad category. But actually, the product that was being provided were only cigarettes, which is just one of the products that you can have from manufactured tobacco. So that's an example. Tijanshu, I hope that answers your question. Um, yeah, I think I already answers Nitika's questions on multiple classes and categories. If I fall only under one class and my competitor files an application in another class, so there will still be infringement, although he can say our products are registered? No. So Nitika, if you have an application under one class, say for instance you're the proprietor of Skechers, right? You're Skechers Inc. and you've registered Skechers. A Skechers is popular enough that if someone applies in another class and Skechers opposes, they might still have some argument. But if, say, your brand was not as popular as Skechers, somebody could get away with applying for that brand for automobiles, for instance. Right? In the Nandini case, actually both products fell in the same category. One was food items and one was milk. Both fell into class 29 or 30, I think. And because of that, the court really had to dive deep and say that even if you're in the same class, doesn't mean you have monopoly over all the products in that class, right? You only have monopoly over the product that you're actually applied for and registered and actually using for. So you can't claim that somebody, Nandini, for instance, for chips, would be so similar that it confuses with milk, right? So it won't be infringement if somebody applies for an identical trademark in another for another set of products. How can businesses determine which class of IP protection is most suitable for their innovation? You mean now broadly between trademarks, designs, copyrights, patents, or do you mean that for different classes of goods and services? So if you have a particular trademark, then you know for the kinds of services that it is being used. Nitika, can you? You're on YouTube, right? Okay. Vistara can be classified as a niche trademark dealing only with airlines, for example. So can it still be protected as a well-known mark? Yeah. So that's actually the entire concept behind a well-known trademark. Is if it's become so popular in that segment of products that it's originally used or applied and registered in, such that a consumer would feel that it's used in any other service or product, it's like an extension of that original business. If it's become that popular, then yes, it deserves that well-known status, which is why Vistara got its well-known status. But for instance, other smaller brands will not get that status, because so many of them have also been, say, rejected for that status. For instance, if you look for, I actually don't want to name specific brands, just in case they feel, but if you think of, say, Metro, right? Metro is very reputed for shoes, but there is Metro Cash and Carry, which is a wholesale store, right? So they're operating in two separate businesses. Metro is popular, but not so popular that anything that they do, any other service that is out there will be associated with Metro shoes. So while they're reputed, they're not so reputed among the substantial segment of consumers. So that's why that's a difference, say, between a Metro shoes and a Vistara airline. And actually, this is a lot has to do with the kind of evidence that you can produce at a hearing when you're discussing your well-known status, whether it's an infringement proceeding or you've applied for a well-known status application, say, before the trademarks registry. The weight of your evidence, how much consumers recognize your brand, testimonials related to that, whether you have enough consumer surveys to prove that your brand is so popular in that segment that, say, Vistara comes with a Vistara chocolate and you would think that the airline business is starting a chocolate brand. So those types of surveys and questionnaires and things like that are some things that brand owners actually do. Reliability of questionnaires and other things is a separate topic altogether, but that's why Vistara got its status for a well-known mark. Okay, I think I've got two more questions. Let's see some examples. Now, for specific, why don't you throw in some examples of draft of their business? Anybody want to give an example? For instance, I showed you examples of clothing. I showed you examples of bicycles, for automobiles. What else? Okay, let's look at, for instance, software, right? So your client is in the business of, say, NFTs, yeah? How would you draft that claim, right? Your client is in the art space. They are in the business of NFTs for specific tokens for art. And let's see how we can draft that. Okay, let's go to EUIPU again. This time we search for non-fungible tokens. And in fact, this is a recent amendment in the NIS classification, which has recently come about in the 12th edition, where they've clarified how NFTs and tokens are to be described. There we go. So now, depending on which type of NFT, you may be in more classes. So what do I do here? I'll say non-fungible token for paintings, right? And I've selected India, which means that the specification that shows up here is accepted in India, or in some form or shape has been in some previous application, and it's aligned with the WIPO, with the NIS classification and the terminologies. So paintings authenticated by NFTs or paintings authenticated, pictures authenticated. So these are all falling under class 16. So I select that, right? And the good thing about this particular tool from EUIPO is that you can keep adding these classes, and then when you look at them, it'll tell you whether you need to file in one class or more classes. Now, for instance, now if I say tokens in music here, if you're providing a marketplace for that, which is a service, will fall under 35. But if you're, say, providing music that can be downloaded and authenticated by tokens, which is what I'm planning to do, I'll select 9. Okay. And then I'll add it to my list. So here's my list. Now I've realized, okay, I'm supplying paintings and music, which can be authenticated by tokens from my particular platform. So here's 9 and 16. But I also have this platform where all of this is hosted, and you can purchase it from my platform. So what do I do then? Then I'll go choose 35, add that, and say token painting platform. Okay, platform is too wide, so maybe you don't want to use that. E-commerce, because I'm enabling purchase and selling, still nothing. Then I'll say non-sale, still nothing. These are all generic terms. Okay, then you realize, okay, maybe you don't have anything for a separate platform. Maybe I'll just say online service. Will I get something? There we go. So similarly, it's the precise science is this, that once you've identified the different components of your services, you then put together those components. Now, if you realize that your components are falling under different classes, these are 3 separate applications that I have to make. And you don't have to limit it to just one description. You can say, for instance, if we've searched for paintings authenticated by non-fungible tokens, let me also look for fungible tokens. Is there something for sculptures, for instance? No, because sculptures are physical. So it won't have, it's not a digital asset. Or it's not authenticated by a digital token. Then if I look for, specifically, if I look for, say, advertisement, again, you may have to apply for it separately as non-fungible tokens and separate for advertisement. So you can also add basis what your business is, and not everything would have been done, for instance, in the past. So here you've got all audio, video, pictures, sport shoes. So similarly, if you have, say, I think in the Meta Birkin case you saw, if it was just bags, so there you've got the bags authenticated by NFTs and things like that. So really, it's a matter of figuring out, again, like I said, your business and how you can describe that. And it's really, you don't have to have very complex terminology to input. This is how you put it together if you're doing it for the first time and if it's new to you as a process. But slowly you'll realize that actually you can describe it just in clear terms of what you're doing, and you test each term against this service. So it's actually a very easy way of figuring out how to describe it. But if you want to see, say, if other applications have been granted in a similar space, then you go to the search tool, which I showed you on the Trademark Office website. Let's see that once again. Okay, you come here, and here, by the way, the class details will take you back to this EUIPO tool, but that's not what we have to look at. If I if you go back to the search, next search, and I want to see just in the non-fungible tokens where we are, you may not find that here. That's why we use specifically um, some certain private databases. So if you were to see, okay, which other brands are registered in respect of non-fungible tokens, there's no service which provides that over here. But if you have a brand that you know of, say OpenSea, I don't even know if they're protected in India, but let's do a quick search of that. And if we see 16 and see if they are present in the paintings, etc., that we looked at. But the way to build your description is actually the easiest way to do that is using the EU IPO tool, and then you can cross-check that against the brands available already on the Trademark Office website in this search. Okay, for some reason it's going very slow. So this has been happening. You will notice this happens from time to time. The servers of our IP India office are often overwhelmed with the amount of activity that's going on, both at the offices and by people like us, of course, lawyers who are searching for all of these things, that it slows down. But anyway, so without wasting too much of your time, I'll just stop this. But this is one way to cross-check what you've already figured out by the EU IPO tool. Any more questions? Do you want to see any more examples? Is this something that's, are you getting familiar with it? Do you want to say, explore something more? And then does anyone have any other questions? I noticed there is a lot of activity back there.
Ma'am, I think there are a couple of more questions in the chat box as well, and people are here as well in the class who wants to ask you a couple of questions.
Yes,
So
please. I didn't see any more questions.
I guess Devanshi Agrawal has posted another question.
Yes, okay. So following the example of Vistara, does it apply only to well-known? For example, if I try to register a lesser-known trademark under a different category, will I be able to do so? Sorry, so I didn't understand your question specifically, Devanshi, but if you have, for instance, what I meant to say for well-known marks is that they're protected across classes. So if a third party is trying to apply for a Vistara mark for, bicycles, they will still be objected because Vistara is a well-known trademark. And so they will not be allowed to register even for bicycles, for instance. But if there's a lesser known trademarks that can be applied and registered, and there will be no objections if it's for different services entirely. And that threshold of whether it's similar services, whether it's allied or cognate products, those are things that will be analyzed by the examiner. I hope that answers your question. Anyone in class who had a question?
Yes, ma'am. A junior of ours have this question that when we were talking about main classes and ancillary classes, so whether do we also register in the ancillary classes the businesses that we as a future prospect we see that we will be undertaking that as well. So we want to grant protection regarding that as well. So for example, somebody was citing the example of Go Mechanics, who is basically a repair and mechanic service online portal. However, now they are venturing out to second-hand EVs as well.
Yeah.
So do we get protection for that as well, ma'am?
Yeah. So in fact, if at the time that business started, if they didn't know that they were also going to enter into this new service or for EV, if they didn't know that, that's fine. If they know that now, they'll apply for a separate application for the same mark. But if they knew that at the time of the original application, they could have either applied for multiple applications for those different services. So you can certainly do that. Does that answer the question, or is there something else follow up on that?
I think that answers the question now. Thank you for that. There's another question.
Yes, ma'am. Hi, I'm Rachna, and it's a really insightful session. I have dropped a question in chat box as well. It
Yeah.
says
It,
that
it,
yeah. So
yeah. So
how
I
do
mean,
we?
it certainly is. It certainly is. Only that we're obviously not seeing the effects of that just yet, um, because we still have to go through these manual tools to put together our description of services and of goods and services. There is no automated tool currently to do that, but I'm sure we're headed in that direction.
So, following up with that question, we humans have this morality thing and all that in picture, but AI is not yet equipped with all that stuff. So, is that can that
Sure.
be a deciding factor on how we outperform AI as in the practice of IPR, especially,
So I mean,
or
for
any other
for
practice?
if we're taking just the example of, say, how to draft a trademark specification, even in that example, um, you're the only one who is going to understand the business of the client. Beyond a point, AI will not be useful if you're not giving the right prompts. So while you can have AI tools to scan, say, an article of association of a company to figure out what a business is formed for, the specific services that they intend to perform. That's only really the broad construct, right? Only you as a lawyer who has that human touch will be able to figure out, okay, while there are these different services in the AOA, what is it exactly that the client is looking to do today? What is it that they want to expand into tomorrow? And what can be allied and cognate and ancillary to what they're doing that should be considered for the broadest possible trademark protection? And those are things that only you can determine as a lawyer. I mean, you can use the tools, and maybe in some time there will be tools smart enough to do that as well, but that's not the case right now. And so you um, certainly need to get skilled in this, on how to understand your client's business and how to search for the right descriptions that you can collate for putting together the specs.
Okay, so as of now, we are all safe from AI.
But yeah, see, the thing is also that the considerations on infringement, etc., that analysis only you can do as a lawyer right now. Um, an AI tool will be able to tell you, yes, this third party is present in the market, and they're doing this business for a similar under a similar trademark, similar business. So you shouldn't adopt it. So to that extent, you will have some information handy. But what to advise the client from with using that factual information, that's still obviously something only you can do today.
Yes, ma'am. Thank you. Makes a lot of sense. Thank you.
Okay. I know the session was shorter than we had hoped, but really that
Ma'am,
covers
if
a
there are
lot of
follow-up.
ground.
Sorry, ma'am.
What is specimen of use and why is it required in certain kind of trademark application and not in certain kind of trademark application?
Sorry, say that again.
And what is specimen of use and why is it required in certain kind of trademark applications? I mean to ask.
Yeah. So, for instance, if your client has a brand that they've been using for some time, right? Say for the past 3 years, they've just not. So in India, okay, let me backtrack a little bit. In India, there's two ways you can acquire rights to a trademark, right? One is statutory protection. That is, your trademark is recognized by the statutory authority, by the trademark office. The second is through goodwill and reputation, which you acquire through just use of the brand. So you could be, say, for instance, just be using the brand, but it's just not registered with the trademark office. For the past 3 years, you've used the brand, you've accumulated certain goodwill, your customers know you, but you don't have trademark protection for it. That's fine. But because you started use 3 years ago, you want to ensure that you get priority from that first date of use. You want to be able to stop anyone who's come after that first date of use, um, right? Who's adopting a similar trademark. So, for instance, you've been using it for the past 3 years, you're applying for it now, and you realize there's somebody on the register already, but their date of use is after yours, right? So it's a similar business. So while somebody could have protected their trademark before you, if their use is after you can certainly prevent them and restrain them. So now this specimen of use is just proof of that first date of use. So when you claim that you've been using it for 3 years, you have to obviously tell the trademark office that, listen, this is an affidavit where I'm on oath testifying that I've been using it for 3 years. And also, look, this is a supporting document which clearly shows that my brand is X. It was first commercially used on this date. The document has that date, and therefore, this is proof that I've been using it. So it's more evidence. And specimen of use is, so ultimately what you have to show is that you've been using it in commerce, you've been using it commercially, right? So simply saying my company was incorporated on X date, that won't be enough. You'll have to tell them, okay, my company was incorporated and I made my first sales pitch on this day, or client pitch on this day, or my advertisement first went out on this date. I hosted my website for the first time on this domain on a specific date. When you can show all of that, that's good documentation to show your prior use. And priority is maybe the first most important thing, even before specifications, is when you first started utilizing that brand. And because in India we're one of those first to use countries, where it's more important to have actual use in respect of goods and services, and instead of a trademark registration. Yeah. Okay.
That was all from the class, ma'am. We are done with the questions. Now Shamna ma'am will be giving you a vote of thanks.
Thank you,
Hello.
Kriti. Thank you. Sorry, I did not join in the beginning. I joined, but there was some technical issues.
No problem.
Actually, this entire debate started. We have a subject called trademark prosecution and
Okay.
litigation. So there,
Okay.
when we were talking about, I was informing them. I was trying to convince them that in trademark also the claims and specifications is one of the important area, like
Yeah.
patents. So then they
Yeah.
were asking that, what is that? What is there, ma'am? It is only that if you look into the publication which is made in the journal, it is only about this, that. I said that no, please look into these forms. If you look into these forms, all these classes, if you are not clear, then tomorrow
Yeah.
some other person will register in the same class with the
Yeah.
same name. So you
Yeah.
have to be very, very clear in your specifications. So from
Yeah.
there onwards, we started and we continued. Then we had a lot of debates on this. Then somehow, they searched that, is it true that whatever ma'am is saying, then they got you. And you are really rich in this resource. And your practical experience is really wider compared to us. Thank you very much for giving us this kind of excellent lecture. And I hope
Thank
all
you.
of our students would have got all their doubts cleared. And definitely, we'll be having the future sessions with you if you are
Absolutely.
interested
Yes,
to
absolutely.
interact with
I
students. Actually,
really enjoy teaching and talking. And it helps me also to ensure I know what I'm talking about.
yeah. But we have a small number of students in the IP specialization.
Let's,
So that's
we
why
can
we have
change that.
less. Yeah, but if
Intellectual property law is one of the most interesting areas of law, I think
yeah.
personally. So I think,
If a general trademark lecture, if you can give, then we will invite all first years and second years also, because there are some large number of students who are interested in the IPR. But since it is very
okay.
niche area, we thought that
Yeah.
very specific area, which is where once you complete the basics of trademark, then you get into the prosecution and litigation. So we have less
Yeah.
number of audience. So we look forward
Okay.
for your future lectures.
Absolutely. Thank you for having me.
Thank you very much. Then, with
Thank
your
you. I hope this
permission,
was useful. Yes,
yeah,
absolutely.
definitely, it was useful. Though I was not on the stage, but I was following from the, YouTube.
Okay.
Um, all those nice classification, then the kind of how you need to understand the classes based on the
Yeah. Sharma, I think I can't hear you anymore.
now. If you can share. Sorry. Huh.
Yeah.
Thank you very much.
Thank you for having me.
Thank you. Shall we end the session?
Yeah. Unless someone else has any questions.
Any questions from the audience? Please put it in the chat box. Otherwise, also, whatever the questions you have, please, if you inform us, we'll discuss with ma'am and then we'll get back to you.
Yeah.
Okay. Thank you for sparing your valuable time.
Thank you. Thanks.
Thank you. You can leave the session.
Yeah. Thank you.